So I'm going to go ahead and read all that into the record, and we'll get started just as soon as our fourth member arrives. Thanks for being here. My name's Joey Hargis, and I'll be presenting the cases for review today in today's public hearing. At this time, I would ask everyone please either silence or put on vibrate your cell phones so that you don't disturb today's meeting. Quite frankly, you probably don't have much reception in this room anyway, so you're just killing your battery. So you probably just turn it off. The procedure will be to introduce the case record as the Codes Department has it, and I'll do that on the wall here by means of a PowerPoint presentation. I'll present any letters in support or opposition to a case, as well as any correspondence we've received from other metro agencies. At the conclusion of my presentation, the applicants will come first to the table and present their case along with any persons in support. And then if there's opposition present, the applicants will step back, the opposition will come up and present their testimony, and then the applicant will have a period for rebuttal. The board in their rules provides in cases without opposition, applicants have 10 minutes to present their case to this board. In cases with opposition, the board provides 15 minutes per side. Now that's not per speaker, that's per side. So if you have multiple people who'd like to address the board, please divide your time now before you come up. In cases with opposition, if the applicant wishes to have a rebuttal, and most applicants usually do, you'll want to save some of your 15 minutes to present your rebuttal. The items that you address on rebuttal are only things brought up by the opposition, and you can't bring any new testimony to this board during your rebuttal period. Just to your immediate right, where you'll be sitting, is a clock. That clock will start after your introduction of yourself. Come up and tell the board your name and where you live. We'll start the clock. It'll run during your presentation. It'll stop for any questions and answers that you. If the board asks you a question, we'll stop the clock. Your answers, we will not be running the clock on that. But once you're done with the answer, we'll start it back up. The board, all section numbers that are referred to today come directly from the Metropolitan Zoning Code, a copy of which is at my desk here behind me, and I'll dispense from reading individual sections unless the applicant or opposition requests that I read those sections. The zoning code applies to the entire jurisdiction of metropolitan government. It was adopted by the Metro Council and became effective on January the 1st, 1998. The zoning code requires that these proceedings be taped. Therefore, it's imperative anyone wishing to address this board to please come forward, identify yourself, and make your presentation. It should be noted that it's found that anyone's presented false or misleading testimony to this board that may have affected this board's decision, any approval by this board can be revoked at a later date by means of a show cause hearing. The board will go through all cases set for public hearing today, and after each case, the board will discuss in front of you and vote on those cases. The board is vested with the power to act on these cases as outlined in Section 1740-180 of the Metro Code of Law. The code requires that 4 members of our 7-member board be present to constitute a quorum. A quorum is just the number of members I need to actually have a hearing. The code also requires that you have 4 affirmative votes to grant your application. Today, I expect no more than 5 members present, so you will need 4 affirmative votes to grant your application. In the event that only 4 members hear your case, you must have all 4, and if you fail to do so, we'll automatically reschedule your case for the next available public hearing, which at this time will be August the 21st. In the event that 5 or more members hear your case, so if we have all 5 members hear your case today and you fail to get 4 votes, your case will stay on our agenda for the next 30 days. We have 1 meeting in the next 30 days, and that's July the 3rd on a Thursday. Your case will come back up on July the 3rd. Any of these 5 members who are participated can change their vote, thus achieving 4, or the 2 members who are not present, or any members that are not present, can watch today's proceedings and go over the paper record and become eligible to vote in that case on July the 3rd. If after July 3rd hearing no one's changed their vote and we're still at a vote of 3-2, your case will be deemed denied by operation of law. The applicant or any aggrieved property owner may request a rehearing of this board within 60 days of today's public hearing. Further, any applicant or aggrieved property owner may appeal this board's decision to Chancery or Circuit Court within that same 60-day period, but once 60 days has elapsed, this board's decision is final and no further action may be taken. If you're an applicant and your case is approved today, you need to follow up with the Codes Department beginning on Monday. and continue working on obtaining your building permit application or use permit or other similar permit. It should be noted that you have 2 years from today's date to obtain the permit for which you've applied. If this board approves you for your case today, let's say you're building something and they've approved you, you've got 2 years to come get your permit. For this board's approval will remain in effect. If you wait 2 years and 1 day and come to the codes department to get your permit, you get to start over because your time has expired. Mr. Chairman, I submit that all cases were filed in proper order. Applicants were notified by certified mail as required by the zoning code. All affected property owners within 300 feet were notified by first-class mail as required by the code, and a legal ad was published in the Tennessean. And before I begin any preliminary announcements, the board allows elected officials to address this board. If any are present, is there any elected officials present today who wish to address this board? Okay, we always provide them the opportunity to come and participate and go first and talk to the board members. So with that, if members, if you'll excuse me for one moment, let me grab my agenda. Okay, a few preliminary announcements from myself. I have cases that have been advertised and withdrawn either by the applicants or by the codes department staff due to code changes. The first of those I wish to discuss is at the bottom of page 3, case 2014-50, CBS Outdoor. It's the appellant James Overby, the owner of the property at 600 42nd Avenue North. This request has been withdrawn by the applicant and will not be heard today. Are there any parties other than the applicant present who were here to hear about case 50? At the bottom of page 3. Okay. Seeing none, that case has been withdrawn by the applicant. And the next case is at the bottom of page 4. It's case 2014-53. Mr. Scott Chambers was the appellant and owner of the property located at 2708 Wortham Avenue. This case was withdrawn by the codes department. Mr. Chambers' proposed construction complies with the zoning code, and so no appeal will be needed. Is anyone here on case 53 that may receive notice? Okay, seeing none. The next two are on the page 5 of our agenda. It's cases 2014-55, Mr. Mark Tant at 2031 Galbraith Drive, and 2014-56, Provantage LLC at 2304 9th Avenue South. Are any parties present or who received notice on cases 55 or 56 present? Okay. Seeing none, we made a pretty good effort to try to reach out to folks and let them know that those cases, both of those were withdrawn by the codes department. Both of those requests do conform with the zoning code, so no appeal is needed on either of those cases. All right, Mr. Chairman, have anything for me before I begin the consent agenda? I can't start yet anyway because I don't have a fourth member. So for the folks behind the desk, I will stop talking. The board will come to order and start its agenda just as soon as my fourth member arrives. And you all feel free to talk amongst yourselves, and hopefully we'll have somebody here in just a few moments.
Which would probably result in me advising you what your policy is. should probably follow that.
That's kind of, I mean, my theory is by the time they pursue and achieve their remedies on this,
You've probably got guidance.
We've got guidance.
I think you're right about that, Mr. Chairman.
So I'm just prepping you for, I think I'm outside the rules, and I don't blame you for not to slap me.
Well, I'm going to try to find a way to talk around that and let that be the outcome. If you don't want to turn to your legal counsel and ask, are we sure we can do that? Then that might be prudent. One of the lawyers who trained me very early on was sometimes it's okay to tell your clients, be mindful of what you don't ask. And Bill was right when he taught me that. Still give him more credit on that.
That's the theory anyway, is why do we keep making?
Well, and it all comes back to you. You know, if the court says, no, you're okay, well, it all comes charging back.
And also, if we rule for the billboard company, Metro appeals, and if we rule for Metro, the billboard company appeals. And so
It goes there either way, now that we've staked our claim on those. And of course, we have the decision now that says, yeah, y'all can appeal it if you want. Boris finished recently, in fact, you got that decision. Who's representing CBS on this today? Is that Mr. Asher? What's Sean? You know?
He's here on Sterling.
the tri-class,
The one that talked about the guy bulldozed. Who showed up.
By the way, my key phrase on that one is minimal utility usage. That's kind of what we hung our hat on, wasn't it? Is that phrase? Because NES records indicate there was some activity within the last 30 months, and therefore we're doing X, Y, Z.
We put it on the developer, the owner of the property, to provide records to us that it has been used as a duplex.
Okay. And so
They provided the records. We had no evidence to the contrary.
And if you guys would, please take your seats. We'll get started. Mr. Chairman, I think I covered preliminary announcements. I do have one I failed to mention, and that actually the case at the end of our agenda was a deferred item from last time, and we agreed to take that case first today. And so I forgot to sort it that way. So actually the first case that we'll hear today will be case 2014-42. The Jocelyn Sign Company is the appellant, Dr. Tommy Ducklow and Beth Ducklow, the owners of the property at 3114 Elliston Place. They're requesting an item A appeal, appealing the zoning administrator's interpretation of 1740-180A in regards to digital signs not being allowed in MUG. Their request is to remove the existing ground sign and replace it with a digital sign in the same location and same height, but to increase the size to a 4x8.
Hey, Joey, are you going to do the consent agenda first?
Oh, yes.
Thank you.
Thank you for reminding me. I'm
No problem.
completely thrown off. Okay, ma'am, if you'll hang out just one more moment. Thanks, I was totally... I'm sorry. Thank you, Mr. Chairman, for reminding me. This board does have a consent agenda. The consent agenda is when a board member reviews the record on each case on today's hearing, and if, in their opinion, the applicant meets the criteria for the application they've requested, and they feel that testimony in the case would not alter the material facts, they recommend the case to the remainder of the board members for approval. I'll now enter into the records those cases that have been recommended by the chairman, Mr. Whitson. for consent, and if you are here in opposition to any of the following numbers I call, please raise your hand, and we'll hear the case. We'll remove it from consent and hear it in its normal order on today's agenda. Today's consent agenda is listed at the top. The first case recommended for consent is at the top of page 2, case 2014-45, JRS Development Partners, appellant and owners of the property at 1601 Porter Road, requesting a variance in the street setback in R6 to authorize the construction of a new duplex with a street setback of 20 feet. Are there any parties present in opposition to case 45? Opposition? Mr. Chairman, seeing none. The irregular shape of this property necessitates the need for a variance. This request actually replaces the existing duplex that's there with a new, more modern-looking duplex at essentially the exact same setback as what's there today. That structure that's there today actually sits approximately 19 feet from the property line. They will be at 20. The next case recommended for the consent agenda is in the middle of page 3. It's case 2014-49. Alan Rogers, the appellant and owner of the property located at 4712 Illinois Avenue, requesting a variance in, and I apologize, my typographical error, is one variance, and it is in the street setback, but is the side street setback in R6 to construct a new single-family residence on this property. Are there any parties present in opposition to case 49 on Illinois Avenue? Illinois, last call. Seeing none, this nature of this request, the hardship is the narrowness of the lot. This request is essentially to replace the house that's there now. The house that is present currently has a 7-foot setback on 47th, and the zoning code would require a 10-foot setback. They're going to take that home down and replace it essentially in the same footprint as well. Would comply with that. Mr. Chairman, I believe that is your consent agenda.
We've got a motion. Is there a second?
Second. Before we vote, we had a latecomer come in. We'll make sure that latecomer was not opposed to one of the consent items, if you would.
Sure. Any parties that may have just walked in, the chair has recommended the following cases for consent. That's case 45 at 1601 Porter Road, and case 49 at 4712 Illinois Avenue. Any opposition to either case that I called? And Mr. King, I did not see who it was that came in. So I don't see a show of hands either. So apparently no opposition to that request. Thank you, sir.
Okay, so we have a motion. Do we have a second? Second. All in favor? Aye. Consent agenda passes.
If you are here for case 45 or case 49, you have been approved. You are free to go. I will, as always, extend the invitation to hang out with the rest of us, which everyone always declines. So, and we stay a consecutive streak on that, Mr. Chairman. So, one of these days, someone will stay and hang out with the rest of us. Okay. As I started to say, our first case today will be the case at the end of today's agenda, listed on the back of, on the end of page 6. That is case 2014-42. Again, I'll read this into the record. Jocelyn Sign Company is the appellant, Dr. Tommy Ducklow and Beth Ducklow, owners of the property at 2114 Elliston Place. They are requesting an IMA appeal. They are appealing the zoning administrator's interpretation of 174180, under 174180, in regards to digital signs being prohibited in the MUGA zoning district. Their request would be to remove the ground sign that's there, replace it with a digital sign in the same location and the same height, but there would be an increase in the overall area of the sign, up to 32 square feet in their proposal. If the applicants come forward to the table. Okay. Doctor, how are you? Good. This case is a little bit different. Oh, right there, sir. This case, and we have another item A case. Item A cases are a little bit different procedurally than normal cases. In this case, we'll go first and put on the testimony. The codes department has it. I'll then turn it over to you, Doctor, for your time. We'll both have 15 minutes. I won't take anywhere near that. And then any other parties who are also interested will have a 15-minute opportunity to address. You'll also have the benefit of a rebuttal time, so if you'd like to save some of your 15 when your turn comes up, feel free to set aside some. Let me just briefly show them some photographs of the site, of what's been submitted, and I'll turn it, and I'll, Bill, are you handling this, or do? Okay. Okay, let's see here. Members, the subject property, just give you a location. This is at Elliston Place and 22nd Avenue North. Dr. Ducklow's building is located on the parcel. It's bound in red here. The property is zoned MUGA. In this case, it was deferred from last time, but just a brief portion from the Codes Department. MUGA prohibits LED signs under under 1732.050 under the prohibited sign section, letter H, says that LED message boards and digital display signs, and it lists out a laundry list of zoning districts, MUGA being one of those, are prohibited except for time, date, and temperature signage. That's the only thing that is allowed. And this is the submittal by Jocelyn Sign into our office.
So our code still has the old bank time, date, and temperature
Yes,
sign.
sir.
Not many of those left anymore, are there, in Nashville?
I haven't seen any in a long time.
Everyone's got their smartphone.
But that's the this is the existing sign, and if I may have a moment, I can blow that up a little bit so you can see the existing sign Dr. Ducklow has here now, and his request would be to, at the same height, keep it, take this down, replace it with the panel which you see there at the same height. But our section of the zone code is just an outright prohibition of that type of signage in MUG. Dr. Ducklow has submitted an appeal of our decision, and so that's why he's here before you today. And really, honestly, that's kind of all I have from the zoning administrator side. Do you have any questions of us as our first one? Okay, that expires my 15 minutes of discussing. Dr. Ducklow, I'll turn it over to you. You have 15, and identify yourself and make your presentation, sir.
I've owned the building at 2114 Nelson Place for close to 15 years, and when I moved in, that sign was already existing, so I'm not sure how long that's been there. My request is to, I think I didn't beat the deadline when this ordinance was put in, because there was a digital sign that was installed right across the 22nd Avenue from me on the side of the building. Pretty big digital sign that you can see coming up Church Street when you hit the peak of the hill. And mine wouldn't be near as invasive as that sign is. I'm just asking that since I've been there that long, and that sign has been in existence as long as it has, much longer than my 15 years that I've been there, if we could have some type of appeal to allow me to install my sign. It won't be much bigger than the sign I have right now. That's the first time I've seen that rendition. That's a nice looking sign. But I think ours is probably smaller than that. That's all I got. That's all I want.
For the record, would you state your name?
Oh, I'm sorry. My name's Tommy Ducklow, and I'm the optometrist and owner of the property 2114 Elston Place.
Any questions?
How does this work if I maybe hear from zoning administrator, then back to?
I think so. And I think, and
rebuttal, ask questions, okay?
yes. Okay, sir. I think you're gonna have 13 minutes and 53 seconds of rebuttal time, if you'd like.
And the next parties actually speak from the Codes Department side. We're done. Are there any other parties present who wish to address this board in regards to this sign? Okay, Mr. Chairman, I see none.
Okay, then I guess we're going to close the public hearing and go to discussion.
It looks to me, obviously, that the sign was turned down based strictly on the compliance with current code. Is that correct?
Okay, any other thoughts?
I mean, I don't see an argument that would have us go against the zoning administrator.
I agree. I understand the logic in wanting to do it, but I just don't see the grounds for reversing the administrative decision myself.
Okay.
Other than it's a nice sign, it'd be a cool thing to have, but
Right.
the rules just don't allow it as they're written now.
Okay, then I'm going to make a motion that the appeal be denied because we find that the zoning administrator did not act in error in interpreting Metro's code. Is there a second?
I'll second.
Okay, I've got a motion, got a second. All in favor? Aye. I'm sorry, sir.
I'm sorry. Okay, I'm done.
You're done. Thank you. Oh, did you want rebuttal? I'm sorry. Actually, legal counsel is exactly correct. There was nothing to rebut because rebuttals. Yeah. Okay. Thank you.
Thank you, Doctor. The case is uphold the zoning administrator on a vote of 4 and 0. The next case, and the case listed on page 1 of our docket, is case 2014-39. Mr. John Reynolds is the appellant. 7A Group LLC, owner of the property located at 5817 Nolensville Pike. They are requesting a variance in the required distances, separation distances from agricultural and residential property in the shopping center regional commercial PUD district to erect a ground sign with a height at 40 feet. The sign itself is not an issue. The issue is the request of a 24-foot LED sign at 30 feet in height on that same pole, referred to the board under section 1732.050, letter G, 2B. The appellant has alleged the board would have jurisdiction under section 1740.180, item B. If the applicant, you want to come forward first? In our usual case, unlike item A's, the applicant goes first as well as any parties in support, and then we'll hear from any parties who are opposed. Is there any, while I'm asking for that, are there any parties opposed to case 39 present with us today? Okay, Mr. Chairman, I see none. You'll have 10 minutes, sir, to present your testimony. Before you begin, though, let me go through a couple items and present the case to the board. The subject property you see here is located in the SCR zoning district. It's at the intersection of Swiss Avenue and Nolensville Pike. Down in the southern part of the county, the structure which you see on the site in this aerial photograph is no more. That has been, again, there we go. Thank you. I'm sitting here talking about things you can't see. There we go. The subject property, as I was stating, is at the intersection of Swiss Avenue and Nolensville Pike, again, the southern part of the county. The structure that you see here no longer exists on this site. This property has been demolished and is being redeveloped into auto service business on here. It is in a commercial PUD district. The planning, and as such, we had to send this request over to the Planning Commission for a recommendation to this board. The Planning Commission has recommended approval of the applicant's request for an LED sign. Now, good, when I turn it over to the applicants, you'll show exactly on this aerial. We'll bring it back up, approximate location of where that sign is located. This is the current site plan that's been issued on the property. As I said, the former use is gone and removed. This is the new facility that's being built on that sign. The sign itself is located almost to the intersection. It does comply with the setbacks off of Knowlesville Pike and Swiss, but it's at the far southeastern part of the site. The Codes Department, we've denied the permit based on its distance to residential districts here. And let me zoom out just a little.
Which is the residential district it's abutting?
Well, actually, Mr. Ewing, I appear to have chopped that off my picture. So I'm going to pull up a map to show you guys exactly that.
And remind us the rules of.
Yes,
how-
the LED signs are permitted in certain zone districts, as you saw in the former case that you just voted on. LED signs are permitted in CA, which is principally the Opryland area,
Commercial attractions.
commercial attraction, CS, CF, shopping center regional, and all three of the industrial districts, so long as you meet a separation distance from residentially zoned property. That distance is a formula which is based upon the height of the sign. So based upon the height of the proposed sign here being at 30 feet, the formula states that it must be any portion of the sign that is the sign itself 4 feet or less in height shall be 100 feet from residential property. And then for each additional 4 feet, for each additional 4 feet in, for each additional foot above 4 feet in height, you have to be an additional 25 feet from residential or agricultural zone property.
Joe, in the agenda it says 40 feet, so is that?
40 is the overall height of the total sign. That's not the issue. The issue is the LED panel sitting at 30 feet.
Okay, gotcha.
Yeah, the overall sign itself is actually fine.
Okay.
Just the LED portions of that sign. The residentially zoned property, again, that sign would be located in the southeast corner of the property. The residentially zoned property is just the immediate property west. The RM15 district is here. This is our subject site, sign sitting down here.
Are there residences in that area?
It's a apartment complex that's there.
Joey, I noticed that there was a TVA tower and an easement.
Yes.
We're not counting that part as far as the distance, are we?
We actually would include that in our distance as far as it's the measurement does include any and all easements that would apply to.
But that's not what's holding this
Not
up?
at all, not at
Okay.
all. It's the proximity of this residential district here and agricultural to the direct south. If you'll notice, here's our subject lot, the corner lot across the street, the next parcel is zoned agriculturally. So it's this distance from here to the agricultural as well as the distance from here to the residential zoning. It should be noted there is actually, and you'll see in the photographs here in just a second, I'll bring those back up. This is our proposed sign. The overall height, again, at 40 feet. The LED panel is 24 square feet here, 3 by 8 on that pole at the 30-foot mark. This is the facility upon my visit approximately 5 weeks ago. You see construction's going on. This photograph is of note. This is an LED sign just to the west of this property that exists, I believe, on the self-service storage lot that's to the southwest. That sign predates any zoning code restrictions upon LED signage, but I would at least make note for the record its proximity to the residential zoning as well. This is the intersection there at Swiss and Knowlesville Pike. I believe the Walmart facility is just a little south in this photograph, a little bit further in the background. So based upon those two spacings, I list those being differently. The larger number is to the agricultural property to the south. It's 427 feet. Based on a 30-foot height in that formula, you have to be 750 feet from either of those zone districts.
And is the measurement to the boundary or to the actual residential structure? Because it looked like there was a lot of green space between the boundary and the structure.
The code spells out actually measuring to the property line itself, the zoning boundary, rather than the structures themselves. looking at apartment complex to the west, this is the clubhouse and administrative offices. Wrong one, sorry.
Are we ready for the applicant to proceed?
Yes.
Okay.
There's the aerial photographs of the area. There. With that, I'll turn over case to you guys. You'll have 10 minutes to present your testimony. Again, members, I'm here if you have any questions regarding the zoning code.
Thank you very much. First of all, I'll introduce myself. My name is John Reynolds. I represent Illuminated Sign Images. We're the sign company of contract with Express Oil Change, our 7A group. Jay, why don't you introduce yourself?
My name is Jay 70. I'm the owner of 7A Group, and I'm the local franchisee, exclusive franchisee for Express Oil Change and Service Centers.
We appreciate you hearing our appeal today. A very integral and important part of the business for Express Oil Change is being able to advertise in an appropriate manner the specials and their services. Due to the location of our pole, where it actually is the only place we could really put it on the lot itself, we aren't able to have any options other than the electronic message center to do this. The reason for that is because there's a retention pond that's exactly about 2 feet in back of where our pole is. So that would prohibit anything other than an electronic message center allowing us to advertise. I don't know if any of you have been on the property since we've improved it, but it's going to be a fine-looking complex once we get it finished. But that's the reason for our appeal today, that it's a very important part of our business that we have a way to advertise that particular aspect of it.
Okay.
And I'm sorry, just under Tennessee law, to justify variance, there needs to be some type of physical characteristic of the property that causes the request for the variance. I read from your application that it's you need the increased height because of
Is that the detention pond?
yeah, the topography.
Yes, sir.
Topography and the detention?
Yes, sir.
Does your detention pond, it looks like a bowl over here?
It does, and if you stand in the back of the pole a foot, you'll be standing in water if that retention pond ever filled up. There's absolutely no way to do anything back there. It comes right up to within a foot or two of the base of the pole.
Do we have any other questions? There being no other questions, I'm going to move that we close the public hearing. Okay. Thank you. Discussion?
Thank you.
Yeah, Joey, do you have the little measurement tool available?
Let's see.
Because I'm just curious to know how far it is from where that pole is going to be to the first residential.
Structure itself.
Yeah.
I'll give you my standard disclaimer. This is not survey or
Yeah, well, I'm just about,
the first structure itself is there approximately 560 feet from it.
okay.
Well, I will say from my standpoint, one of the reasons we ask for a recommendation from planning is to get their views, and I find it quite compelling that they advise us to grant the variance.
Yeah, I agree with you. Planning is not so quick to issue these letters, and if they're fine with it, I'm fine with it.
Yeah, the reason I wanted the measurement too is just to see what the effective variance is versus the property line, and an LED sign may bother folks in the clubhouse, but it's probably much more apt to bother folks in their home, and so it's a 140-foot variance. It is fairly compelling that it's in a commercial zone that allows signs like this.
Yes.
It looks like the sign is actually facing
the traffic area, am I right or wrong?
Yeah, does the sign,
Rather than the
does.
residential area. So.
I think you're accurate.
so it doesn't even look like it faces the residential
Right.
zone anyway, so that it shouldn't affect the residential zone, which I think is the main concern of folks that we hear concerned about this.
I'd like to make a motion that the board approve the variance because all of the requirements of MCL 17.40.370 have been met, and the board finds that the unique characteristics of the property are the topography and the detention pond. And I'd also like to note that we find it compelling that we have received the guidance of the planning department to vote in favor. Is there a second?
And I would like to add the amendment that it cannot face the residential area.
I'm fine with that amendment.
It definitely will not fail.
Okay.
We have no reason for it to fail.
Okay.
Okay, so we've got a motion, and it's been amended now, and is there a second?
I'll second it.
Okay, got a second.
Mr. Chairman, for your vote, just since I don't have my court reporter today, just for purposes of Channel 3 in the record, Mr. Harper is eligible to participate in this case.
I am.
Great. So, all in favor?
Aye.
Any opposed? Passes.
Good luck.
Case has been approved on a vote of 5-0 with the conditions as stated. Mr. Chairman. Okay, our next case is case 46, 2014-46. Mr. Mark Culpepper and Mr. Gavin Duke are the appellants. C.E. McNeil, Ed Ucks, the owners of the property. Now that may have changed since. This was at the time the filing of the appeal with my office. This is in regards to the property at 2305 A and B Sterling Road, requesting an item A appeal in the RS10 district, appealing the zoning administrator's issuance of permits 2014-4440 and 2014-12945, and I'll go over those in just a moment. Referred to the board under Section 1740-180, Item A. The applicant has alleged jurisdiction under Section 1740-180, Item A. As you saw in the first Item A, a little different. Code Department will go first and kind of tell our side of the story, and then I'll turn it over to the appellants in this case, and then any other parties who wish to address, but appellants feel free to come forward now. While I'm here to have a show of hands of folks who are other parties interested in this case, be it the landowner or any other parties, we do have those parties present too. And additional parties for the appellants, are you guys the last group that raised your hand with the applicants before, folks at the table? Okay. Mr. Culpepper, Mr. Duke, you'll have, if any of these folks wish to address the board, it'll be during your 15-minute portions. Again, you'll also have the benefit of a rebuttal after we go and Mr. Henry back there goes for the property owner. You'll have a period for rebuttal as well. But again, only items that are raised during our 2 points. Members, before they begin, it's actually our first to go. Let me set up the case for you. This case comes before you, again, appealing the zoning administrator's interpretation. This particular event is based upon a letter that I wrote in this. Back, I want to say, and members, I believe you have a copy of my letter. What's the date? Date of my letter is November 25th of 2013. We get requests in our offices for determinations of legally non-conforming uses on a pretty frequent basis. Part of our job in that is determining, is the item that's being sought a letter, is it legally non-conforming? Our office asks for NES records to be provided in these situations in RS when we're claiming we have a grandfathered duplex. What we do is look to the time in which the property was rezoned from R to RS. And so the point of the rezoning is when the non-conforming clock starts. The zoning code says that, and I'll read from that here in just a moment, that essentially you have 30 months in which you must continue to use this property continuously. You cannot abandon the use of the property, and I'll read specifically the code section that's at issue here. But essentially, we look from the time, when did it become grandfathered based on rezoning? And then from that point till today, have there been any periods of inactivity of greater than 30 months? So I was approached by Mr. Tuck and notified him that we would need some NES records. He provided our office the following documents, and I believe you guys have a copy of it, but if you're looking for your packets, it'd be these 2 pages. This came from the applicants, but these would be the NES records at issue, which listed 2 meters on the property. The first being turned on June 6th of 1966 with no periods that it showed ever being turned off, as well as a second document listing a second meter on the property that was turned on as of 9/26 of 1980. So based upon those 2 documents, I made a determination that this is a legally non-conforming duplex, and based upon this NES record not showing the power being off at any time from 1966 or 1980 until the time I wrote the letter, that there has been continuous use of the property. This has been the policy of our department, I want to say, essentially since the metropolitan government was formed, was to ask for records. Other items we do time to time ask for would be rental agreements if necessary, other utility bills, although not as determinable because there's not a requirement that you separate water meters for a duplex or a multifamily. The codes department, even at some points in the 50s and 60s, did not even require separate electrical service meters on duplex, and it was around the mid-70s when that was required. The gentleman for whom this room was named, Sonny West, that was the policy when I came to work for him, that we would ask for these NES records, and so long as we didn't have any periods of inactivity listed in that time frame, that we would deem those as legally non-conforming. Permits were issued. First, let me read the relevant code section. Zoning code in section 1740-650, letter B says inactivity of non-conforming use. Now again, this covers uses not protected by 137208 of the state code, which is principally commercial uses. So residential uses have no state protection for 1 and 2 family dwellings. So we look to the local law, and the local law says this, that letter B, when a non-conforming use has been inactive for a period of 30 continuous months, the land and its associated improvements shall thereafter only be used in accordance with the provisions in this title. An intent to resume the activity shall not qualify the property for continuation of the non-conforming use. And it lists out a section for purposes of this subsection, the 30 months is stopped or told based upon a couple items. One of those most interesting was the May 2010 flood. The council amended this section of the code to give folks 5 years in the event they were displaced from a grandfathered duplex and it was flooded, to give them time to work out with insurance companies and whatnot. So we're fast approaching that date of that clause coming in. So based upon the evidence submitted by Mr. Tuck, I wrote the letter saying that it was a legally non-conforming duplex. Permits were issued by our office to demolish the structure and to reconstruct. Let me pull up those 2 permit numbers. Members, I apologize, I don't have direct access to our permit data, but I can get it through the This data I'm looking at is of note to everyone watching this. It's actually open to the public and available for anyone's review at the website which you saw I placed in there. Not sure that dash is required. So this is the first permit listed in the caption. This was to construct a new two-story single-family townhome. For us, you've seen the horizontal property regimes. It is essentially two separate, and this board's dealt with these cases. Those two tax parcels are effectively, for the purposes of Census Department, single-family townhomes. But from the zoning code, we look at that as a duplex, and it meets the definition of duplex. So under our zoning code, if you have a legally non-conforming duplex, you are entitled to demolish said duplex and reconstruct it. You have 2 years to do so under our code. The first permit which you saw issued there, 0440, is one of the 2 units there. And I believe the other permit, 12945, is also the second of the 2 units. Yeah, it is. So that's I guess the recap from our standpoint or our view of it. Based upon the appeal, you'll note we did put a hold on both these permits and halt construction pending this appeal.
So at the risk of being overly simple.
No, please.
The issue before us is, was the duplex inactive for over 30 months?
Yes, sir.
Okay, thank you.
Yes, sir. I believe that, and obviously I'll turn over to the appellants to state their case, but that's what we believe from our standpoint. That's the question of inactivity.
And when was the zoning changed?
The zone change occurred in 2005.
2005, January.
And so the only, in the criteria that you use was the power on?
Yes, sir, and that's what we've done.
Not usage, not...
We've never gone to that level of looking at individual months and such, but is the power on? And as I said, Sonny, it was sort of the logic of our office, if the power's on, why would they pay for both sides? It showed activity by having the meters on for that period of time. But any other questions for me, since my 7 minutes is all I have left?
Okay, please proceed.
Okay.
Good afternoon. My name is Mark Culpepper. I'm a resident of Sterling Road.
And Gavin Duke, I'm 2302 right across the street.
So Mr. Hargis had touched on several points, and thank you for your summary of our appeal. We're speaking to the fact of the non-conforming use. We can show and prove by the documentation. I believe you guys may have before you that we presented last week. If not, I'm going to speak to a couple of key documents to that. But one of the things that you were discussing a second ago is the actual usage of utilities at this property. We, with the help of Sean McGuire, our councilman, were able to obtain copies of that usage pattern. So what we can see back as far as 2008, specifically with water, there was zero usage. So that would indicate to me that nobody lives there as one item to look at. Power, as Mr. Hargis alluded to a minute ago, while there was 2 meters, both in the same name of the previous owners, the McNeils, what he had did not actually show usage. So again, we obtained those records from NES as well that shows very little usage. And as NES states it, it's usage enough to continue service at the property without turning it off is essentially what it amounts to. So the other items we're looking at, or that we would like to show you is, we have several immediate neighbors that have lived there, longtime residents that have lived on both sides of the property as well as across the street that can speak to the fact, and we have signed statements from them, that no one has lived in this house since the previous owner passed away in the fall of 2008. So if we look at non-conforming use and the code and the way it's written, it has to be continually used, as Mr. Hargis said earlier, as a duplex during that time frame of 30 months. No one has lived in this house that we can find record of, at least since 2006, when the previous owner was actually moved out of that house for whatever medical reasons and passed away in 2008.
And I can speak to my wife has called the codes department 5 times to request the grass to be cut. It's been an unsightly sort of property, and we called them. We have 3 phone calls in 2013 on record at the Metro Codes, 1 call in 2012, and 1 call in 2011, just because of the grass was waist high and really abandoned at that point. And also, I'm a landscape architect and have to deal with ordinances and zoning and in several different cities and jurisdictions. And in our mind, this is sort of a zoning violation because in 2005, it reverted to RS10, and we have a signature from Mrs. Charles McNeely that I think you have in your packet that states that it went from R10 to RS10 at that point, and it did not. It was not part of an opt-out. In the map there, you see the R10 across the street, which opted out, and there's one on the corner. Both those people are here today, and we talked to Sean McGuire about getting them to opt in for the neighborhood, just for the use of the street. It's a single-family street. There's plenty of conforming single-family residents on the street, so. That, in our case, is what we'd like to prove.
I'd like to kind of continue on that point. So stepping back a little bit, our neighborhood 10 years ago went through the process of changing this zoning in our neighborhood for very specific reasons. And what we did, and I say we, I had just moved there. So there were some neighbors that actually made this effort happen. But as Mr. Duke stated, one of the key points in this is that the owner at that time who lived at this property signed this petition that was ultimately passed as an ordinance in January of 25, and that was Mrs. McNeil. So at that time, that house was changed to RS10, which is single-family residence. And at that time, I don't believe in 2005 it was used as a duplex even at that point. And we have several neighbors that can speak to that fact again, that show that there was no resident living in that side of the duplex when Ms. McNeil moved from the property, I think in 2006, and again, passed away in 2008. And since then, that house has been abandoned and not used at all. Couple of other.
What do you mean by abandoned? No one owned it?
No one owned it. Well, it was owned, but no one lived in it. It was not occupied.
Why is that being abandoned if someone owns it? They pay the taxes.
I have no idea.
No, that was your word. I mean, abandoned. Tell me about this abandoned.
Bad choice of words, I guess. My statement should have said no one lived at that house. The owner, I'm not sure, but I think it was one of the family members, as best we can tell. Whether it's tied up in probate, I'm not sure.
Okay.
All I can speak to, and actually the neighbors can speak to it better that lived across the street and on both sides for a decade, is that no one occupied that house, not a renter, not an owner, et cetera.
So, I'm sorry, I'm being simple today, but the evidence you're presenting, you're not disputing the evidence that the Codes Department reviewed and relied upon. You're simply supplementing that with additional electric records, water records, and then testimony that no one was there.
No. And so the reason I say that is if you look at only what Mr. Hargis had at his disposal, that doesn't tell the complete picture. All that says is there was 2 meters.
No, that's actually, that is what I'm saying.
Okay,
I mean,
I misunderstood you.
I'm just trying to, you're not saying the information Codes relied on was inaccurate. You're supplementing it to give a more full picture, right?
To provide the correct picture. That's correct.
Thank you.
And the correct picture is that based on the usage, it was not used in accordance with if it had inhabitants. Does that answer your question? Yes. Okay. One other point I'd like to make that was brought up a minute ago as part of the code is from the flood of May of 2010, and there's a specific piece in that code that says if that property was reported as having damage, that would extend that period of time, I believe, to 60 months. I have a map that should be in the packet that you guys have that shows that if you look at our street, it'd be in section 2 of the documents I provided. I don't know if you have that in front of you. if you're looking at that map, you'll see different colors. And the two different colors are going to be either be damage that was reported by the occupant or owner of the house, or damage that was confirmed by the city. If you look at our street, you will not see any damage reported, and specifically speaking to this property, do not see any damage to that property from the May flood of 2010. So I just want to point that out, that should not be a factor in this. That
Yeah, and in
It does
fact,
not extend the
the
time.
code actually uses the word significantly damaged,
Right.
not just damaged.
Right.
And interestingly enough, the code says as a result of the severe rain event, not the flood, the severe rain event that occurred May 1st and May 2nd of 2010. Interesting wording, former councilman.
Okay, would any of the other neighbors like to speak? I mean,
Yes, I'd like to ask one of the immediate neighbors specifically, Carol, would you like to come forward? Carol can speak to the fact that no one has lived in the house for a number of years, and there's also several other neighbors that we have. I'm not going to, given our time factor, I'd allow Carol to speak for them on their behalf. Carol?
It's pretty intimidating, you know this. My name is Carol Gerlach, and I thank you for the opportunity to address you gentlemen. My mother and I moved into the house in 2307 in 2004. Mrs. McNeil and I had lots of neighborhood chats. She was very specific to me that no one was in the apartment on the second floor in the attic. The apartment had been lived in the past by a graduate student who had completed all her degree work, gotten a job in New York, and moved to New York, but said she'd keep the apartment in case her committee wanted her to come back. In no time from 2004 till now has anyone lived in that apartment. I'm an old lady. I look at it all the time. I was afraid the building was going to burn down or a meth lab be in the basement. I don't know. But no one has been in that apartment. And then when Mrs. McNeil had that terrible fall and had to leave, well, then she was out of there also. And I'm pretty sure that. Pardon?
I'm sorry, when was that?
I believe it was right around 2006. Can't be specific about that. Dollar General could tell you because they were very upset that she fell in the parking lot. Anyhow, and then she could never come back to her home. I mean, she came with a caregiver down the driveway to look and see if the house was all right, but she wasn't in that house. And ultimately, she was more care than her daughter could provide, and she went into a facility before she died in 2008. So I can tell you, gentlemen, absolutely nobody's lived in that house.
Had you ever been in that house before?
Had I?
Yes.
Yes, Mrs. McNeil, we were neighbors, and she said, I had, went over and sat in the living room, we chatted. She came in, she wanted to meet my mother. My mother passed away in 2010 at 96, and Mrs. McNeil was very kind to her, and there was a lot of chatting.
Had you been in the other unit that was rented out?
No, that's in the attic upstairs. It's not a side-by-side thing. It was, no, I would have no reason to go up there.
Okay. Thank you.
so your testimony is that since 2004, it hadn't been a duplex, and no one's been in there since approximately 2006?
The 04, I'm solid on. I can't remember when she fell, but I believe it was right around 2006, because I know she was gone for several years before she passed away in 2008.
Okay. In the interest of time, with the board's indulgence, instead of having, this is a question, repetitive testimony, if the neighbors would simply raise their hand, and for the purposes of the record, I'll count the hands and report it, if that's okay. Neighbors, if you agree with that testimony, would you raise your hands? Good gosh, this may put up my counting. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18. Joey, please feel free to check me, but I think there were 19 hands raised. Okay, is that fine with the applicant? I'm not trying to cut you short, it's just...
That's agreeable, certainly. I would like to point out on that note, however, that we also have petitions that the entire neighborhood signed, and last count, I kind of lost count, but it was around 100 individuals signed petitions that speak to the same fact, and that they're in support of this.
I just like to give credit to anybody who will show up. I mean,
Mr. Culpepper,
if you've taken your afternoon,
And we did get
is that something you've submitted already?
Yes.
Yes, and then
Okay.
of course, we've had additional ones, but you've received the bulk of them when we turned that in on Friday.
And we did get a letter from your councilman.
Yeah, I was going to make sure that you did see that, and he is in support of our view of this as well.
So, the people that own the property now are not the McNeils.
As I understand it, but all I can do is look on public records.
Okay.
But that's my
Joey,
understanding.
The McNeils are deceased, right?
Correct.
Well, I mean, or the family, or their heirs. I didn't know
Yes.
if the people who had the demolition permit were the owners, or if someone...
We can ask the next person who they represent.
As far as I can see, again, based on the permits that we saw, the demolition was provided to a builder, and I believe that was Focus Builders, if I'm not mistaken.
Could I add one thing? Can you hear me? We're not opposed to construction. We're not opposed to a single-family house being on that property. As you can see, Joey, in the overhead view that you had earlier that had all the houses for that street, it doesn't fit the character of the neighborhood, and I think that's what concerns Sterling so much, that we went through this process in 2005, and it would really disrupt that sort of, with two houses on each side being about 18 feet tall. And I had conversation with the developer. He came by my office and I met with him. We looked at the plans together. He asked me what we could do to make this right, and I said, build a single family house. I said it doesn't fit with what we have currently in our neighborhood.
And again, last point, I think, just to kind of wrap it up on our side and reserve some time for later. Mr. Duke makes a valid point and a good point, but again, it goes back to specifically speaking to the code and the fact of how it was or was not used. And in this case, it was not used as it was originally built and intended. And so that's our argument here. So, you have any?
Great, you'll have 6 minutes and 15 seconds for rebuttal. And now we've got the opposition to the item A.
Besides the two gentlemen approaching the table at this time, are there any other parties, I don't know how to couch that, in opposition of the appellants? Okay, seeing none. Mr. Henry, and you'll have 15 minutes between the two of you guys to present your side of the story, and with that, I'll turn it over to you.
Thank you, Mr. Secretary. Mr. Chairman, members of the Board of Zoning Appeals, my name is Sean Henry. 315 Dedrick Street. I represent the property owner. In fact, there are two owners here. On my right is Mr. Tuck. He's the one that negotiated the acquisition of this property and is one of the owners of one of the units, and is here to answer any questions as to his involvement with this property during the time that he's had involvement. I don't know that we have anything here that would necessarily refute the information you've just heard. The issue, though, is not occupancy. The zoning code does not speak to whether use equals occupancy. So I just want to throw that out right now because that's really not before you. I believe the codes department, the zoning administrator, got it right. I think this permit should have been issued based on their evidence, the evidence in front of them, the tax assessor evidence, and we'll provide you with some of that if you haven't already seen it. In fact, some of the testimony that you've just heard, I think, proves the fact that the owners of the property intended to continue the use of the property as a duplex structure, and I want to touch on that. The only, I guess, statement I would say about the letter from Mr. Hargis is that he used the word provided it has not been vacant. And again, vacancy is not in the code. Occupancy is not in the code. I would have preferred to use the word discontinuance, so long as that activity has not been discontinued. But when you take a look at the NES records going back to 1966 and 1980, it clearly shows, as the appellants have pointed out, a continuous use of the property with electrical service in 2 meters. There's an upstairs unit that was an apartment building, and I would like to just hand these out for the record if I may. And this is the first time that you really see something official in a government or quasi-government record regarding inactive. And if I may, the very first item you see here, and I've taken the liberty of highlighting this record from NES, is the premise history just provided on June 2. On the first page, you'll see in the very middle, the meter is the upper meter or the upper pole. And you'll see where it says turn on. It was turned on in 1980, September 26, and it was turned off on April 22 of 2014. On the next page, second page, I've circled the status of this meter, which is now inactive. And that inactive date, again, coincides with April 23 of 2014. So this meter and the other meter, which is in here a few pages back, it too was turned on. It turned on as early as 1966, June 6, and then it was turned off on April 22nd of 2014 this year, very recently. So these records indicate that for the entire time that property had meters, those meters remained active in use, and there's no dispute as to that.
Excuse me, Mr. Henry, I'm sorry. When was the property sold to the current owners?
April 23rd. It was either 23rd or 28th. It was two different buyers. HF Holdings, which is myself as a general partner, bought Unit B, and the Powers Living Trust, which is a family, bought Unit A.
So we're seeing on April 23rd, that's when NES said the meters were turned off. Did you turn off the meters?
No, the seller did.
The seller did?
The seller turned off the meters as part of
the deal.
Yeah.
Okay.
The closing occurred 5 days later on April 28th. And importantly,
okay. All right. I got you.
And just so you know, I'll back up a little bit, but what was transferred here, the conveyance here, was 2 units. Each unit, according to the HUD statement, sold for $207,500 each on April 28 of this year. So we have a continuation of usage of the property for a duplex based on NES records. I'd like to share with you, and I was glad to see a few minutes ago, Mr. Hargis was able to bring up the tax assessor's website, but I will hand out to you just a quick printout, or we can pull it up on the screen if necessary. This property is being designated by the tax assessor as first commercial property since 1963. And the building style was designated an R1 duplex, and the assessment for this property was as a duplex for that period of time. The narrative description of the property states that for assessment purposes, it is as commercial with an R1 duplex style building. On the next couple of pages, I printed out the records that are only available online. There's certainly records that go back earlier than 1994. But what you can print out from the website are these records, and so at least from 1994 to 2013, you see that it is the same owner. It was the same owner. The fourth page is just a printout of the tax year 1994, and here you can see that the classification for the property is commercial C at a rate of 40%. So the tax assessor for many years has been, at least going back to 1994 and most likely prior to that, has classified the property as a duplex property.
Mr. Henry, so those who don't know, if you have a duplex, you pay at a higher rate than a single family, correct?
That's correct.
And these people paid the duplex rate the entire time?
They paid the commercial rate of 40%, which is the same rate that you would pay if you had a business, retail business, restaurant business, commercial piece of property.
So the difference between the residential rate and the duplex rate is what?
25% for a residential single-family home, single-family property. For a duplex, it's 40%.
So the prior owners could have said, hey, let's save some taxes, no one's in there, we're going to pay 25%, notify the city.
And I don't know if you've had a chance to see a letter. I asked Mr. Hargis beforehand if this letter that came in yesterday from the prior owner had been distributed, and I'll distribute it now. But that's exactly the point, or one of the points that the prior owner was making. And this is Michelle Radford. She had her letter notarized to this Board of Zoning Appeals. And in here, she's saying that she grew up in this property, and it was in her family's name the entire time. The home was built somewhere around 1940, but at some point in the 60s, they acquired it. She grew up there. The property was used and maintained as a residence with an upstairs apartment since she was aware of it. The whole time her parents are the McNeils, by the way, and they passed away. The apartment was furnished and had a separate electric service meter. She says that in early 2013, we replaced the roof, the siding, and the gutters at considerable expense. And I also have, for the record, she submitted to my client their contract. They spent $14,000 and almost $15,000 last year, 2013, in replacing the roof, gutters, and siding on the structure. But to go to your point, Mr. Ewing, she comments that if there was any interest and intent to abandon and voluntarily relinquish the status of this property as a duplex, they would have notified the tax assessor so that they could get that lower tax rate, to drop it down from a 40% assessment to a 25% assessment. And secondly, they would have told NES to disconnect one of the meters so that we're not paying for 2 meters. And so that's her letter to this board.
She also filed the horizontal regime.
And earlier this year, as part of the contract for conveyance of this property, the agreement struck with the seller, and Ms. Michelle Radford was the representative of the estate of her parents. The deal was that she was required to establish the horizontal property regime, and you now see the outline of the 2 structures that are part of the site plan that was created prior to the conveyance of this property on April 28. So again, it goes back to intent and this idea that has it been abandoned or has the rights been relinquished? The property owner voluntarily created a 2-unit structure for the conveyance of the property to my client. So
that was in negotiation with your client?
That's right. So it was the seller, the prior owner, continuously in the family hands, converted it from duplex to 2-family structure. So it was 2, and it's now 2. She created 2.
But she also inherited it in 2008 and didn't use it as a duplex for 6 years before she sold it.
Well, we can't speak to the use. We don't know about that. In terms of occupancy, can't speak to the occupancy. You've heard testimony about occupancy and whether people were in there or not in there, but what we can tell you is this letter testifies is that it was furnished.
Mr. Henry, would it make a difference to you if nobody lived there for 6 years?
Well, I guess that's the question for this board is being asked to rule on, which is unprecedented. I could find no case law that talks about or assigns the question of occupancy with the idea of whether you lose your non-conforming rights if you're no longer occupying the space from a residential perspective.
But that wouldn't have changed your mind if you knew for sure that nobody lived there for 5 or 6 years.
No, I don't. That's exactly what I think is before you. I don't think it matters whether there was active occupancy at any given time during this process. The issue that you're being asked to address is where does that 30 months come into play? 30 months of cessation of activity. My point is you only get to that if you find that the evidence indicates that the property has been abandoned, that the owners have voluntarily discontinued their use of the property. You think about some issues about our soldiers going off to war and they're not occupying their residence. You think about missionaries leaving their home and going overseas and they're not occupying their residence. Do those folks risk losing any property rights that they have as a home because they're not occupying their residence?
Well, in those cases, though, that you assume that rent's paid, you assume that other, things are paid. And I guess the question I would ask you is, what, in your opinion, would it take to show non-use over 30 months? And you know, thinking of a lot of different examples. One comes to mind, you have somebody has a car lot, have a sign out front that says, I'm selling cars, and they go out of business and they leave, and the owner of the property doesn't do anything. It sits empty for 30 months. It's not a car lot, but it's not zoned to be a car lot, and somebody else wants to come in and have a car lot. I mean, there's been no rent collected, there's been no activity, there's been nothing that says there's been anything there. Should somebody else come in and be able to put a car lot because they never took the sign down? So I guess what would constitute a 30-month, I mean, you're saying abandonment, and you're saying things that I think are fairly extreme and probably wouldn't happen. What is there, and I don't mean that as a challenge, I'm saying it's no one's going to, I don't think that any property owner, especially the deceased, is going to say, hey, I'm no longer there, I therefore give up my duplex rights. Tell me what is a 30-month vacancy that would cause that rule to go into effect in your mind?
It's hard to compare this to a business situation where the general public is coming up and opening up a door and they can see hours of operation, or they can see a sign that says closed for business. This is a residence. And so what you're being asked to determine is whether or not people are coming and going from a residence that they can freely occupy or choose not to occupy. So I think from an evidentiary standpoint for this board is, what evidence have you seen where the property owner has terminated the use of the property as a duplex? What do you have in front of you that says they've willingly, voluntarily terminated a decision that they are not going to use this property any longer for two families? And what you've got in front of you is an investment of $15,000 just last year by the owner of the property, the prior owner, in a roof, in siding, in gutters. And I'm going to draw your attention to your own language.
Do you have any evidence? I'm sorry.
Okay, if I put gutters on my house, it's still single family. I mean, how do those repairs signify duplex? I'm not trying to be dumb. I just don't understand.
That leads me to my next point, which is the language in your zoning code. And so under 17.40.650, this is nonconforming uses. Item B, inactivity of a nonconforming use. The use of property is in quotes, and it's defined here. Use of property shall mean a function or operation that constitutes an activity occurring on the property, period. So function or operation. The question is this property functioning as a duplex? It is. It's furnished. It's got meters. It's got water. You can walk in there. You could have walked in there before it was demolished at any point in time and occupied. There's nothing preventing anyone from occupying that space as a tenant or the owner, because all of those things that are necessary to demonstrate the use of the property, what is it intended to be used for? It's intended to be used for a two-family residence, and it was available for that use. And so you look at that definition. Does it function as a two-family residence? Yes. Does it operate as a two-family residence? Yes. At any time, consistently. The sellers were maintaining this property. There may have been calls to the health department for high weeds, but my God, that occurs all over this city. Constantly, homeowners are being reported about high weeds. This idea of very low utility usage proves the point that it was continuously on. It was continuously operating. The meter may not have been spiking because there wasn't a whole lot of use taking place, but the use of the property as the property is intended for a two-family residence has never been interrupted. So if there were that interruption of those functions and an interruption of that operation, its ability to operate as two families, that would have been the triggering point and the beginning point of the clock to tick for 30 months. We've not hit that point. That clock has not begun to tick based on the facts that's been presented to you.
It would have begun to tick on April 22nd, right?
It would, yes, sir. I would agree with that. Absolutely.
Let me ask you a question. This letter, Mrs. Radford, this is the daughter of the couple that lived there and
yes,
passed away, correct?
That's correct, right?
That's correct.
Yes.
That inherited the house. I find it a little curious, the second line in this, my family and I, what it says, the first line, I grew up on the property and inherited from my deceased parents. My family and I actively used and maintained the property as a residence with an apartment, with an upstairs apartment. To me, that's sort of implying that they used that after she inherited. Am I right or wrong?
I don't know. I honestly don't know.
But it's,
I mean,
my
I think
testimony so far, there was no one living or residing in that dwelling in the last X number of years. Am I right or wrong?
that may be correct. I cannot refute the occupancy level, the tenancy of any of these two spaces. But again, that's not the issue. The issue of occupancy for a non-conforming residence is not in your zoning code. Now, the Metro Council could certainly have inserted that into this language and said, when we're talking about functionality and operation of a residential structure, we mean whether it's been occupied or unoccupied for a period of 30 months. But that's not what this says. So I can't speak to that. I think it does imply that there were two structures. I think it's expressed that the letter says there were two structures for as long as they could remember. Excuse me, 2 units. One structure, 2 units.
Mr. Henry, I know you deal with these issues a lot, and you don't have to answer this if you don't think you can appropriately, but when the horizontal property regime was conducted, I'm not sure what the proper verb for that is. What is the process for that?
When you have R or RS zone property where you can have 2 units, the process does not involve the metro government, other than on the tail end of that process, the metropolitan government will assign a tax parcel number, as they have here, and as it's indicated, the outline of the structures now show up on metro property maps. But the seller created this back on February 14 of this year. Excuse me, that was an amendment.
That's it was February 12th. And then
February 12 of 2014, Ms. Radford, on behalf of the estate, created the horizontal property regime, which is a legal instrument that's recorded in the Register of Deeds office, and was the basis for which the permit was issued for construction.
So the codes department saw that there was this horizontal property regime in place.
Correct.
Okay.
And that's one piece of evidence that we don't find that the codes department, in this case, the zoning administrator, has erred in any respects. And frankly, I don't know how you can expect your government permit issuers, the zoning administrator in this case, to know whether someone's occupied or not. The government just doesn't keep track of whether somebody is adhering to their lease, whether they've left for whatever reason, whether they are no longer residing in a particular spot. The government just does not maintain those records. So based on the records that the government does have, that the zoning administrator relied upon, the records that we have obtained the same set of records, we think there was every reason for the permits to be issued and to recognize this property for the right to have 2 structures. If I may highlight one point, I don't want to get too legalistic here, but there's one case, which is a Tennessee Supreme Court case in 2010. It's the Smith County Regional Planning Commission versus the Hiawassee Village Mobile Home Park. Again, that's a commercial piece of property. It's about the only one I could find that involved residential occupancy. Ultimately, the mobile home park lost on that case on another issue, but the Supreme Court said the issue is whether the use of the property is based on its operational status. Its operational status. That's exactly what your zoning code says. Does it operate as, in this case, a duplex? The Supreme Court says, what's the operational status of the non-conforming use? How does it operate? Can it operate? Is there anything keeping it from operating, in this case, as a duplex? There was nothing to prevent that.
I guess that what I'm trying to think of, and maybe you can help me because I really am struggling on this one, is it, if I have a restaurant with a kitchen and tables and chairs and plates and food in the refrigerator, but I never open my doors, I never advertise, I never have a customer, am I still a restaurant? And that's, I don't, there hasn't been any evidence presented that it was advertised for rent, that it was rented, that it was occupied. And I know that you're saying that, you're saying, well, no, this is, a duplex is a duplex without having those things. But I'm having a hard time with it. So, help me understand where my thinking is wrong.
Well, first, the burden of proof is on the appellants who are challenging this, and I haven't seen any evidence that they presented that suggests that there were no advertisements for rent. We don't know. I don't know. We don't know. Very well could have been. We don't know.
Or was there ever advertisement?
Point to your question, your analysis, even though you could call it a restaurant, was it operating?
Yeah, that was.
What is operational?
That's a better question.
What's the intent of operation?
Can it operate?
Back to your verb of operating.
Yes.
Trying to understand, and I get your point, but that where I'm struggling with your use of that term is in the example that I'm presenting to say, well, what makes something operating or not, and is it more than just, is it any kind of traffic? Is it, we have had testimony that there has been no activity, that there aren't people there, that they haven't testified that they've seen cars come up and people look and signs in the yard and that kind of thing, and that they may testify for on rebuttal more specifically. But I guess the term goes back to what operating. Why is my thinking about operating wrong?
I really don't know how to address the hypothetical of a restaurant. I really just don't. These are such distinct factors for a residential use, residential occupancy, and the ability to operate it as a residence. Other than to say, if the restaurant were closed for business and they were in front of you today because the zoning administrator issued them a permit to allow a new restaurant, and the people were saying, but that restaurant, and they bring forth evidence to say that the restaurant closed its doors or whatever those dates are. Each issue is fact dependent. And so the facts that we have here needs to be applied to the law, which is, can it operate as a duplex? Does it function as a two-family residence? And it did. Could you say that about the restaurant? Would a restaurant that's non-conforming, could it open the doors back up? Sure, you could. And then you get into more analysis. So I'm sorry I can't really use that analogy to help you appreciate our plight, but I'll tell you what's being asked of you as a board is to overturn the zoning administrator on evidence that they do not readily have available to them to know whether someone is occupying space or not. On the issue of residence, you mentioned lease. It could just as easily have been a mother-in-law's apartment. It's attached to the house. So you wouldn't necessarily have a lease. You wouldn't necessarily lease. You wouldn't necessarily advertise a mother-in-law's apartment, for public review. But I think the slippery slope here for this board is that if you're considering this unprecedented ruling that a house that's unoccupied constitutes the loss of the right to use it for its intended purpose as a duplex, you're going to face a lot of these kinds of cases coming before you. I haven't seen any case that's gone this far. And you're being asked to go way far afield from the case law, and I think way far afield from what your own zoning code says as to non-conforming use. I can't speak to occupancy, but I can speak to the activity on the site. It was actively being maintained as a duplex. It was home improvements were made just last year. You have that evidence. They were mowing the property. They created a horizontal property regime while they still owned the property. And before they conveyed it to my property, to my client, they established that and sold it as a two-family structure. So now the equities of the situation are that you've got an innocent purchaser who purchases a horizontal property regime, two structures, goes and gets a permit, and had previously done his due diligence. Remember, just last November, the testimony was, we got Joey Hargis's letter that says you can move forward. And he did so. So you're asked to overturn something that's way down the road, and substantial monies have been expended in furtherance of, the duplex permission, and we just asked this board to uphold the decision of the zoning administrator.
I'm sorry, I know you've already said this, but I'm going to ask everyone involved here. What do you think the legal standard we are to apply is? I think you read the definition of use earlier. Can you read that again? Because I'm going to ask the appellants and I'm going to ask our own counsel just to make sure I know what standard we're supposed to travel under.
Sure. Yes, sir. It's clear under your zoning code that the use of the property, and that phrase is in quotes, the definition of use of the property shall mean a function or operation that constitutes an activity occurring on the property. Function or operation that constitutes an activity. Remember, they're saying it was inactive. Well, what function or operation was occurring on the property that constitutes activity? And we submit that the NES records, the tax assessor, the water records, which frankly I didn't have a copy of, all of those demonstrate that the property was functioning and operating as a two-family structure. Whether it was occupied or not is immaterial.
Okay, thank you. Any further questions? Okay, we're going to let the appellants come up for their...
Thank you, Board.
I think it was like 6 minutes and 35 seconds. I can't remember. 6:15.
Thank you.
Thank you.
Excuse me, I'm a lot to absorb, a lot to take in. I have to think about all that for a minute. I guess let me start with a point of clarification. While we've been talking and used the term occupancy, I'd go back to the code and look at to Mr. Henry's verbiage he used was usage and activity, and it's stated in the code. I guess if I look at a couple of things based on what he just covered, so if I were to look at what the property assessor has on his website, there is a statement that says this assessment is not a zoning designation and does not speak to the legality of the current use. So if I were, let's go down the path of the question you guys had a minute ago, and that was the car lot, the restaurant, et cetera. And also the question about taxes and what type of taxes, they were paying, whether it was commercial or residential. So in this case, if they were paying commercial taxes and the usage and intent was to, and at some point actually used as a duplex, to me that implies I have a renter, right? If there is a renter in that property and it's set up for commercial uses, what I would be looking for proof of how it was used, when it was used, how long it was used, would be rental contracts, lease agreements, cancel checks, something to show how it was actually used. I mean, just because we have a building that's divided and at some point in the past used that way.
So why would you pay commercial taxes if you could pay residential taxes?
Well, there's that, but the other side to it, I think, is a lot of times in these cases.
Wait, I'm sorry, I didn't.
I would think you would do it for resale, probably. It was inactive, and it would be for...
But if that be the case, they're protecting their property rights to resell it for a higher amount, presumably, because somebody else can do this.
And I'm not sure, I think it was in probate, too.
Yeah,
so
that was for a number of years.
But can you think of any other reason why someone would pay a 40% tax rate when they could pay half of that?
Would probate prevent them from paying residential taxes?
No.
I can't speak to that. I guess...
Well, you raised it, so it's your argument, so I'm trying to suss it out here.
I guess the way I would look at it is, in a lot of these cases, the daughter might not have known that she had that option. And again, if I would go down Mr. Henry's path as well, I can't speak to that. All I can say is, if we're going to say that they were paying commercial taxes, I would like to see records of how it was used. I would like to see records that show lease agreements again. I would like to see checks that were written, some proof of how it was used to show that. And again, while we use the term occupancy, and we did speak to the fact of how the utilities were used. That's just painting the picture again, just to say no one used this house as a duplex. It was not occupied, nor was it used as a duplex. I did not have a renter there, did not even have the original family or any of its immediate family members there itself.
And I know there's other ones on the street. In fact, next to Mr. Culpepper, there's a rental duplex there.
Right.
And they do understand that they have to keep that actively rented in order to keep their use.
That's correct.
So that's there's another one down the street as well that's a quadplex that they keep it actively rented.
If I may.
What,
sorry, yeah.
technically,
Oh, you can't.
technically, you don't get to rebut unless you spoke, but board, I will say, I'm the guy who said, does everybody raise their hands? So I feel a little bit personally responsible for these gentlemen not speaking if you were planning on speaking.
You know my opinion on this. This is kind of an unwritten rule of the BZA, and I never agree with it, so I'm saying let them speak.
Oh, I'm leaning towards letting them speak too, because I'm the one who got them to raise
But I
their
don't
hand.
think, just going forward, I don't think anywhere in our code says that we cannot let people who didn't speak the first time come back.
I think I feel the same way, I think. But I'd like to know what our council thinks about.
Without any declaration of standing policy for today or at any date going forward, I would note that the unique circumstances whereby the chairman identified the folks who were here and wished to give the general statement of, yes, I agree, there was no occupant during said dates, could be interpreted to have kind of shut down the discussion at that point and thus failed to give people the opportunity to speak during that time. I actually think with those unique circumstances, it's appropriate to let folks speak on rebuttal with what remains of their rebuttal time, still within that time frame, of course. But again, I think that's today's unique circumstances, and I'm very quick to not...
I just hope to avoid nasty letters from a chancellor.
Yes, you may get them from your council next time.
So should we move to allow it, or do we just allow it?
I think we're in agreement that it's okay for these folks to speak, as long as it's within their time.
As long as they're
allocated
addressing
time.
issues raised on rebuttal.
Do you want to make a motion?
Can I make a motion that we accept their testimony?
Yep, glad to. Okay, we've got a motion, we've got a
And
second.
I'll second it, and just as long as it's within their allocated time that they have
Okay.
left.
Motion second, all in favor?
Aye.
Any opposed? Okay, please speak, and I'm sorry for the formality.
All right, my name is Charles Smith. I live at 2304 Sterling Road, directly across the street from the property you're talking about. I have lived there for approximately 30 years. A rough calendar. My dog is now 7 years old. She has never seen anybody on that property, ever. I have never seen a rental sign. I've never seen a lease sign. I've never seen anybody on that property since the family that lived there before. Thank you.
Did you ever see a for rent sign while they were living there?
No.
Was it ever rented while they were living there?
I couldn't tell you whether it was ever rented. I've never seen anybody use that.
So we don't know if they ever advertised for renters since 19.
I don't know whether they've ever.
But you said you lived there 30 years, so you've seen that property during that period
I've
of
seen
time.
that property. I talked to the McNeils when they were there.
Okay, but you never saw a for rent sign?
I've never seen a for rent sign.
Okay, and never saw someone that looked like a tenant either?
No.
Okay.
Also, I know the roof was repaired recently, but that was due to the hail damage, not the flood. Though, if you're talking about the great Nashville flood, it would have been due to hail damage. My roof had to be repaired at that time too, but it was repaired quite a while ago. So it would appear to me that was just preparation for sale. Thank you.
Yeah.
If I may on that point, I actually had a note to speak to that as well. That entire neighborhood received, you can call it significant, whatever kind of damage you want to call for hailstorms, and everybody in there had a roof and gutters repaired. So this was not, I would call a specific case of saying we're keeping up our property in the efforts of using it going forward like this. Everybody got a roof and everybody knows that insurance paid for it. I mean, that's a known fact.
Okay,
I'm sorry, Mike.
My name is Mike Zenzer, and I was the guy that walked around and got people to sign the petitions to do the rezoning back in 2004 that was approved in 2005. January the 18th. Mrs. McNeil signed that petition to have her property rezoned. It was on the map showing that it was rezoned to RS10. And I would think the responsibility would be with the city or Metro to change the tax records on that from that point, not the homeowner who probably doesn't even know they're paying a 40% rate instead of a 25% rate. Thank you.
Any other questions from the board? Okay, then I'm going to close the public hearing, enter into discussion.
Mr. Chairman, before you do, they still have a balance remaining if there's anything they need.
Oh, I'm sorry. Would y'all like to say anything?
Anybody?
Address any other issues on rebuttal?
I don't have any further. Thank you.
Okay.
Thank you for your time.
Thank you for your time this afternoon.
Okay, public hearing closed, enter discussion. Before we do, I'd really like to ask our council what our legal standard is. Mr. Henry read it. I have no reason to doubt him. I'd just like to hear it from multiple sources.
Sure. The idea here is, obviously, the crux of the discussion is whether or not the nonconforming use has been inactive for that operative period of 30 months. And the key language comes out of the zoning code is 1740-650, which deals with nonconforming uses. Subpart B analyzes the inactivity language and discusses specifically the nonconforming use and whether it's been inactive for a period of 30 continuous months. In subsection 1, we have this sentence: for purposes of this subsection, quote, use of the property, end quote, shall mean a function or operation that constitutes an activity occurring on the property. I'll read it again because this is what you're focusing in on, I think. Use of the property shall mean a function or operation that constitutes an activity occurring on the property. If you had hoped to avoid trying to figure out what constituted use, good luck, you're in luck. You don't have to figure out what constitutes use. Instead, you have to figure out what constitutes activity, which is probably no more easy for you as board members to parse through. But that's the key language. I'll be glad to pass around this fresh copy of the code if you want to look at mine. But one last time, use of the property shall mean a function or operation that constitutes an activity occurring on the property. Thus, if the board determines that there was no function or operation that constituted an activity during that 30-month period, then you would determine that there has not been continuous use, or more specifically, that the nonconforming use was inactive. On the other hand, if you determine that whatever took place there was a function or operation that constitutes an activity occurring on the property, then you would say that it has not been inactive, or more to the point, has remained active, and therefore the nonconforming use remains intact. I'll be glad to pass this down if anybody wants to look at my copy.
Thank you, sir.
So I would like to point out, as we get into our discussion, that as we've been reminded before, that we're not a board of equity, and I know that at least Mr. Henry raised an issue of equity in people's investments and stuff. That really isn't an issue here, unfortunately, but that is not something we're tasked with. I just wanted to put that out there for the record, those in the viewing audience.
We've had some of these cases before. David, you alluded to a car lot case that we dealt with and tried to figure out whether that was an abandonment of use or continuous use or whatever. What I look for is, did they intend to give up the prior use? And for its duplex, the things that you'd have to do is maybe turn it into a single-family home. If there's stairs up the top, take the stairs down, get rid of a meter, things like that. And in this case, I don't see those kind of things. We see the exact opposite. Letter of the daughter basically says, look, I paid the higher tax rate. We didn't have any intent to not have this except for 2 independent dwellings. And I agree with Mr. Henry that we're supposed to look at the evidence that our zoning administrator looked at too and determine whether he erred. And based on what I see, I don't see an error in the judgment of saying that this house, although it seemed that the evidence showed that maybe it might not have been occupied, but the use of having it being a duplex was not intentionally given up.
Well, I have to lean on the words that he's talking about, the activity. Nobody's shown any activity. If they intended to continue the use, why didn't they at least try to rent the thing out or make an effort? We can't question, and we can surmise, what their intent was.
The code
Intent is not in question here, I don't think, in my mind.
The code speaks to function or operation. To me, function or operation is paying for 2 meters. You don't, that's a added expense.
A higher tax rate.
And a higher tax rate. I mean, this property at the height taxed for over $8,000 a year. That rate would have been much less under the single-family residential rate.
Personally experienced the flood and the activities or inactivities that go on with that. I was one of the lucky ones and had power on my property. Couldn't get to the property, but I had power. And I elected to keep the meter running, which it still is, and it's still unoccupied. But I found out it's much cheaper to pay that minimum amount that they charge a few dollars a month than it is to pay to have the power turned off and turned back on. So
This was over a 5 or 6 year period. I mean, so when you talk about paying higher taxes, I mean, we're talking about thousands of dollars in taxes alone, and I don't know how much in having 2 meters versus 1 or no meters at all.
I'm sorry. Go ahead, David.
Well, I was just saying about the tax rate. I mean, it's, it'd be a 37.5% discount to change the tax rate. I mean, that's a significant tax savings on anything, right? I mean, if you revert to residential, then even if it was $8,000, I mean, you're talking, here I'm doing math, $1,500 a year savings.
And David, to use your kitchen example, there's a restaurant that used to operate on Church Street, which we know what it is, and the person's gone out of town and opened up another restaurant apparently. But I'm sure there's still kitchen equipment in there, and I'm sure there might even be some tables in there. To me, if you were kind of to abandon your use as a restaurant, you take out the kitchen equipment, you change the insides to another use. I think right now, if someone wanted to open up a restaurant in that location, it would probably, outside of it hadn't been occupied in a while, be pretty easy to kind of set it back up. It's got a commercial, water, everything else.
I mean, and I understand that. It feels like a real stretch. Because I mean, and that's the example I gave is a little tougher one, and as the attorney said, they're almost all case specific, because in that one you might have a different landlord and a tenant, and if I'm the restaurant, I'm a tenant and I just abandon it because I ran out of money and business. The landlord doesn't take it out. I mean, it's just, I think that is probably maybe a bad example on my part, but I'm with Dick on the activity is what I'm struggling with, and there is evidence that by not changing the taxes, it says, well, we think we have a duplex, but on activity and operation and whatever verb it is we're really supposed to use, I guess that's activity. Even though you felt like you had it, there was never an attempt to use it that way.
I look at it, the burden is upon the appellant, and however you define activity or use, of all the things that the property owner did prior to the death of the owners, except for having a renter in the rental space, there's no evidence that anything changed. There was no counter activity to the status quo. there's no evidence that they ever advertised for renters. There's no evidence that the second unit was constantly occupied or occupied 4 out of 30 years or 29 out of 30 years. And the question, where's the evidence that anything changed? I don't really see it.
I think this may be a situation where we all have different rationales, but I'm going to tell y'all my rationale right now. When I read the legal standard, which is use of the property shall mean a function or operation that constitutes an activity occurring on the property. Speaking for myself, I'm not exactly sure what the standard should be when you say an activity, but it's going to be beyond my capabilities to say that the zoning administrator acted in error if they applied the same standard they've applied since the beginning of Metro, which is, do you run electricity to it? And I mean, because they applied the standard they've been applying for 30 years, and we got to determine whether that's in error or not. And I can't, what is the proper activity? I'm not sure, but I'm not willing to say they're wrong.
Well,
Yeah, I think
and I
that's
guess and I'm sorry.
I know. I was just saying, I think that's why Sunny West came to kind of an objective third-party standard saying, well, hey, if somebody's still paying an electric bill, particularly 2 meters, that's good enough for me. And, so that someone's proving that they haven't given up this use or not.
Yeah, I mean, I'm sympathetic with the appellants because I do think it was not used and didn't have activity. And I'm also trying to think through, though, and I'm not even saying I'm as smart as Sunny West was, because he really came up with a lot of really good rules of thumb and that we still use and were used for a long time and seem to be fair in the way to do it. And what's coming to mind is, well, if that's not the way you look at it, then how would you look at it? And how would you look at it in a way that was fair to the property owner and also the neighbors? And I don't have anything that comes to mind that says, hey, there's a better way necessarily to do it. But because you on one hand, if you are buying a piece of property or you're selling your own piece of property, you should be able to have codes tell you this is what you can do, this is what you can't do based on some kind of fair way of determining that. And I guess that does come down to it. Is this the fair way to judge it, even though in this case it may be with kind of a queasy feeling because of what some of us may think of as inactivity and others may not.
I'm incredibly sympathetic to the applicants too, because it is, I believe nobody's been in there since 2006. I believe that the mother agreed that she would be single family. It's just, that's not our legal standard, and so I don't know. I in a case this close, I can't find that they acted in error, because we're sitting here working like heck, and it's just clear as mud. It really is.
That brings me to another question that I had for our council. What is the presidential value of this ruling? In voting one way or another, are we, if we vote in favor of the appellant, are we saying, well, we are saying that the administrator was in error, so are we setting a precedent? Because I know in many of our cases we are not. And are we in effect saying, you can no longer decide it that way, you've got to find a better way to decide?
These cases are typically so fact-specific and dependent
that there's not much precedential value at all. The fact that there was an intervening zoning change in 2005 is not enough to sway the analysis for future cases that fall on the zoning administrator's lap. The fact that there's an occupancy/residency issue dating back a number of years is not alone to sway the issue for future cases. So all of these things are so fact-specific that honestly it wouldn't carry tremendous precedential value either way.
And so if our decision were appealed, whichever decision we make, I guess what I'm getting to is what is the end result beyond this case? Because I know it is fact specific, but what the appellants are alleging, as I'm hearing it, and you're all welcome to change or offer to change my mind on this, is the reason that he was in error because he didn't look at the correct evidence, or he didn't look at enough evidence, and that is his error. They're not saying that his error was that he did what he performed the policy that of codes is to check with NES to see. They're not saying that he did that incorrectly. They're saying that the policy is incorrect because that's not enough. That's not enough information because all of their testimony and evidence has been, look at all this other stuff that we believe is relevant. So that's why I'm asking, what is the net effect here? And are we saying that he made the wrong decision because he looked at NES records and he was wrong? I can't think we can say that. Or are we saying that he's not doing his job properly and is the policy wrong?
To the extent that I grasp the core of your question, Mr. Harper.
If you grasp it, I will be impressed.
You owe me a cup of coffee. It's what are we really saying in the event that the board were to vote to uphold the appeal as presented and basically say that the zoning administrator acted in error. I think the effect of that would be that based upon the data that is now available to this board, it has become evident to the Board of Zoning Appeals that the zoning administrator arrived at an errant outcome. Now, that obviously would come with the understood caveat, and I don't think it really holds any big sway in terms of anybody's decision to appeal or not appeal, but with the caveat that more evidence, more data, more documentation has been presented at this later date than was available to the zoning administrator and his staff when they originally reviewed this. So I don't think it's necessarily any sort of damning commentary on Metro staff and their review of what was presented to them, only that now there is more information available to the BZA and that you believe that an errant outcome was reached by the zoning administrator, if you'll permit that passive verbiage.
And so then a follow-up to that question is, are we in any way preventing this from happening again? And I mean, I don't mean that in a lazy way. I mean, if we're saying he was wrong for doing that and nothing changes, we're going to hear this every time. In a way, we are setting a precedence by saying, oh, look, you can appeal this for this very reason because this is their policy, this is what they review. So just go back and say, you're not reviewing enough information, and we'll keep hearing that over and over. Would we not?
Without that rather express statement from the board in its final action today, I don't think that's what it would do.
Okay. All right. And I'm sorry, I didn't mean to take it in such a tangent, but I just wanted to clear that up in my own head.
You know, I kind of agree with where Chris started with this is I think we need kind of clear and convincing evidence to overturn the zoning administrator, and it hasn't been really like 100% he was wrong. I mean, some of us think, well, maybe, maybe not, but it's not really overwhelming.
This is definitely a situation where I would not, I would not look down on anybody's vote on this. This is just a very, very difficult case. Having said that, is anybody ready to make a motion or?
I will attempt one. I move that we deny the appellant and find that the codes administrator was not in error. And do I need to state Anything beyond that, please?
I would change that to the zoning administrator.
Oh, I'm sorry, what did I say?
Codes, so, and with that change, I'll second it.
Okay, so we've got a motion, we've got a second. All in favor, say aye. Aye. All opposed?
No.
Okay, so we've got a split board.
Okay, ladies and gentlemen, procedurally, the case, yes,
I was voting no, so it was not for.
three votes yes for the motion and 2 against. Okay. Under the board's rules with a split vote or a tie vote, as our rules call it, remember, as I discussed at the beginning of the hearing, you need 4 affirmative votes to grant your application. In essence, there needs to be 4 affirmative votes for the motion. There is not. As such, this case is tied. What occurs is this case will stay on our agenda for the next 30 days. We'll only have 1 meeting in the next 30 days. That's July 3. The public hearing in the case is closed, so no new evidence can be submitted. These members are permitted to change their vote at the next hearing publicly. The 2 members who are not present can watch the YouTube stream that we record each meeting on, review all of the documentation that's been submitted today, and become eligible, but that is their discretion if should they choose to become eligible. They'll then vote as well, and I'll call them out individually. Have you read the record? Do you wish to participate? And then would you like to place your vote? The first call I'll make is, do any of the members who voted in this case wish to change their votes on July 3? So we'll get that resolved, and then I'll ask the 2 members who are not present, if they're present at that meeting, do they wish to participate? If we still stay, as we're here, at 3 votes and 2, the appellant's application is denied by operation of law, and the zoning administrator's interpretation will be upheld under operation of law. An appropriate order will be entered as such on the July 3rd.
So the 30 days is?
It's 30 days from today's date.
And whatever change or stay, that's it, but there's no contacting, no discussing?
No, there's no discussion.
No mean looks?
Yes, well, the public hearing is closed, so that all parties, Mr. Henry, gentlemen, and other members present, no emails to the board, nothing else can be submitted. This record's closed on this matter. With that, this case is over for today on a tie vote of 3 for the motion to uphold the zoning administrator, 2 against.
Can we take a 5-minute recess?
Yeah, the board will stand in recess. We'll be back in just a few moments. Thank you. The board will be back in session. If you'll take your seats, please, we'll begin. Mr. Chairman, during the break here, we had a couple items that were actually originally on the consent agenda, which we pulled for opposition. During the testimony of the prior cases, the 2 parties have actually sat down and worked out their differences, and they no longer have an objection. And I asked you guys to put cases 47, 48, and 54 back on the consent agenda. 54 would be with the conditions of 2, 3, and 4 is listed in the Planning Commission's recommendation to you.
Okay, so we have a motion for those 3 to be added back. I'm sorry?
Actually, do we have a motion? Oh.
He's moving.
Right. We have a motion to put those 3 back on the consent agenda. Is there a second?
I'll second it.
Okay, we have a motion, a second. All in favor? Aye. Any opposed? Passes.
For cases 47, 48, and 54, your cases have been approved. You are free to go. And Mr. Ewing, you seconded each of those. Okay, the next case before the board will be at the top of page 4, case 2014-51, CBS Outdoor, the appellant, North Charlotte Avenue Holdings, LLC, the owner of the property at 613 11th Avenue North, requesting an IMA appeal in the required distance from residential, distance from another digital sign, distance from another billboard, required height allowed, and that the downtown code zoning district does not allow billboards. This property is in the downtown codes district. The request is to replace the monopole static billboard with a digital billboard on its eastern face. If that's it's referred to the board under section 1740, 180's item A, 1732, 150, G2 and G4, B7 and B6, and 1737, 110, which is the downtown code. The appellant has alleged jurisdiction under section 1740, 180, item A. Mr. Chairman, if you'll give me just a moment. Somewhere in the break, my machine is run afoul here. Guys, I'm sorry for the delay. I'm having to open up the prior version of this PowerPoint. I've somehow lost what we were just looking at. Okay. Looks like I've got this one back. This is case 51. This is the subject property that you see here. It's on the, it's listed at 11th Avenue North. 11th Avenue would be on the eastern boundary of this lot. The other streets in question are Clinton Street and Joe Johnston, and then Interstate 40 or I-65 South on the western hand side. This is the aerial photograph of the subject property. Aerial is a little dated. This structure, which you see here, is no longer on the premises. This property has been demolished. All of these structures are gone. The billboard in question, it's tough to pick up on this aerial, but it's located right where my cursor is, and then a ground shot of that subject billboard. As you saw from the aerial, all those structures that were around this billboard have since been removed. This being an IMA appeal, the zoning administrator will go first for 15 minutes. Mr. Herbert.
Can I ask, this is me, and I'm going to ask for a point of privilege here, if y'all will put up with me. I'm genuinely trying to figure out why we're doing this, because CBS has been before this board before, and we've ruled in your favor, and we were promptly sued by, or appealed is a better way to put it, by Metro Legal. We've also got a Lamar case that's been appealed. I think this is on the exact same points, and this board has almost yelled into the moon, can we have some guidance on this, because we rule the same way each time, and it just leads to appeals. And my understanding is this has now been argued at the appellate court level, and we're expecting a ruling. Nobody knows when the Court of Appeals is going to rule, but it should be within a couple of months because they heard it a while back. I feel almost no matter how we rule in this case, it's going to be appealed to Chancery, and we're just going to generate more litigation when this board has wanted guidance and we're about to get guidance. Why does it not make sense for everyone, you, us, and Metro Legal, to defer this unilaterally, or to just defer it until we get guidance from the Court of Appeals?
The big issue is getting down our permits before someone else can. And that's where the issues are coming in, is that other billboard companies are wanting to do the same things, of upgrading their signs. And this is just replacing the face where the pole's already there. We're not changing the height or anything of that sort. It's just putting the new face on there. And the longer someone else, if they get one within 2,000 feet, it blocks us from doing that.
So it's the Tennessee law of 2,000 feet that's got you worried?
Yes, sir.
But wouldn't they, by definition, unless they've already got one, have to come in front of us as well?
Yes.
Well, but so how about if we just defer you and put you first on the agenda for whenever we have a court ruling? I mean, because really, this just seems like wasted effort to me. And again, we ruled in CBS's favor, so I'm not trying to be particularly hard on CBS. I just feel like we're about to waste 2 hours, make a decision, get appealed no matter what, and simply get to follow the appeals court decision whenever it's made.
As long as it's in a deferred position versus a striking it and starting over again, we don't have objection to that.
We can defer it, and we could defer it until after the ruling.
Right. I think that would be, in my opinion, because I do agree it's the same issue, and I know that we've had a court case that has come down since, and that court case might influence the way some of us feel about it now, and so deferral means the status quo is kept until the court rules, which I think is probably the best answer.
Can we defer to a date uncertain and make it the meeting that comes after the appeals court decision?
Or just defer it.
And I guess the mechanism.
And the other thing you said, have them first on the agenda.
Sure.
But I have a question here. Do we not have to issue some sort of a ruling within 60 days or something?
Not unless we're deferring it. We're not hearing the case. We're deferring it.
And I was going to say, not if we're deferring it, because we won't have heard it yet.
Right.
The only obligation for item A is that you do hear it and decide, but if you defer it to a
If we
later
defer
date-
it, that doesn't trigger, so.
Correct.
That's why we don't need to get into this.
Well,
How about,
That's the right question.
but are we, I don't want to get into anybody's argument here, but I know their concern is, making sure their place in line is held. Or is there any potentiality where someone could get a legally conforming sign in the 2,000-foot radius that would block them in the future if we defer this? I'm looking to make this as complicated as possible.
With the pole sign already being present on the subject property, then another sign going up, a pole sign of that nature, within 2,000 feet, the concern that the applicants have expressed here today, the person, company B wanting pole sign B within 2,000 feet would also be in need of a variance, thus coming before this board, in all likelihood, I would hope, with consistency,
okay, so
being treated the same way.
there couldn't be a new sign put in there without...
And I'm not an expert in this area whatsoever, but I did represent a property owner once against a billboard company, and I remember that you basically couldn't put up a billboard within 1,000 feet of each other in this area. So
It is 1,000 feet for a new sign. It would be 2,000 feet from another digital on the same side of the interstate.
That would be the distance at first.
well, so any digital sign would have to come before us so that we could, I guess the question is, are you comfortable if we defer that your place in line is guaranteed? And it's a question for you as the appellant, but also our legal counsel to give us comfort on that, because that's important. We don't, in fair play, you should be first in line.
And may I ask, Mr. Smith is the real estate manager for CBS, and he has the knowledge of the billboards. There could be a sign over there that would not require, and this is not a variance, it's under 13.7208, would not require to come up in front of y'all based on spacing and residential, and I just want to see.
The truth of it is, on the next appeal, on Powell Avenue, that sign is there. We were trying to put a digital on the south face of that structure, not changing anything but the face. We've been called within the last week about a piece of property that's actually on Powell Avenue, and apparently the property owner has been approached by now a third person, including us, about a digital sign. That's what it's going to take from a lease standpoint to pay the freight, if you will. If that permit is issued, and I do not believe that it would come under any restriction because there is no residential property within 1,250 feet, which would be a 50-foot sign, that one potentially could be a problem. If that one is issued, and Metro Codes, in their definition of the separation of digital signs, says 2,000-foot radius, whereas the state of Tennessee says 2,000 feet straight line. There's not a chance that we could be, I don't think there's a chance that we could be spaced out from the state standpoint, but possibly we could on the Powell Avenue sign. Well, because I know this for a fact because I just made a bid on the property.
Well, let me.
Yeah, go ahead.
Let me take that scenario, and the person that gets the permit first, that's where the radius is drawn. I'm assuming.
Right,
so.
Exactly. Yeah.
Joey and council, by starting this process and deferring, are we?
Well, that's the discussion we're having. If just the filing of the appeal by these applicants and vests them in this project for the purposes of distances and such. And I think the consensus we've come to would be yes, they would be vested in this location because they filed their appeal. Some subsequent.
That's my view. They don't actually have the permit, but they've tried.
Yes, I mean the application's in. They filed. They're before this board.
And we're going to put it immediately on the agenda of the next meeting after whenever the court rules.
I think absolutely, because just kind of for records purposes, and it is public record, there are other billboards that have been filed for later agendas that are all hinging on this court case. So we're moving them all back.
But we haven't told anybody else that they're going to be first on that case after the hearing.
And but they're on later agendas.
Right.
Already.
And the thing I have to be sure of is that it's not the interplay of a third party that negates these guys or any other billboard company. Like, let's say, for instance, they go across the street on the other side of the interstate and it conforms with the code and we issue a permit, that they'd be vested in this spot. Now, what it may do is your action might grandfather them going forward, but it wouldn't in any way wipe out their opportunity to have their sign.
Well, so ultimately,
we wouldn't have a problem with it if that's the case.
Right.
And have a decision and have it.
John, do you?
I mean, we don't want to deny due process by any means. So I mean, as long as you're comfortable with it, and we all have.
That's about as close as we can get it, frankly. I mean, I don't mean to sound like that's a tepid endorsement. I think it's the right way to go, and I think it's the right way to do, as long as you're preserving the bite at the apple for these folks, and I think that we do in that regard, without necessarily interfering with any of the third party. They're seeking variances. They're going to seek some, well, I guess it's technically an item A appeal, but they're going to look for some exceptions to the rule by whatever means. Still give them a crack at that when the time comes. And certainly, as everybody knows, this is no guarantee of whatever outcome. The Court of Appeals will give direction, and everybody will know a little more about how best to proceed. But I think this strategy that's kind of been put together is probably the smartest one for the board.
The only interplay I have to be certain of is that other appeals that have also been filed do not conflict with this applicant's appeal. And to my knowledge, none of the other appeals filed, hearing one would negate the other and vice versa. We have to make sure there's not, I filed first, so I get, and y'all granted me, now you're out. I'm not aware of any interchange there.
Well, the bottom line is our rules allow us to set the agenda, and once we've set the agenda and promised the first slot to somebody, we stick by that. So you have the first slot.
Well, thank you, sir.
So if we rule in your favor, that's when you can say we were first.
Okay, with all that, I'm going to make a motion that we defer this case until the first meeting after the Court of Appeals rules on the CBS and Lamar cases, and that they will be first on the agenda.
I'll second that.
Okay.
And everybody's comfortable with that, the way you worded it.
And understanding too, just for the members, one scenario of the Court of Appeals ruling would negate all the cases. Sure. In theory, you may not ever hear these, so just kind of keep.
Yeah, if they win, then they don't come back, and we get to.
Okay. And there are There are two separate appeals. They were not.
Yes, we understand that,
together.
yes. We got two very lengthy packets.
Thank you for that, by the way.
So, members, for the record, I need...
Two motions.
Not necessary. In my paperwork, I will enter two orders, identical.
Okay, so got a motion, got a second, all in favor?
Aye.
Any opposed? Passes. Thank you very much.
Thank you.
Thank you, Board.
Thank you. Oh, Chris, good call.
All right, Mr. Chairman, the final case on our today's agenda, I can get to it, will be case 2014-57. And is it Vong Pufa, sir? Is it correct? Thank you. Please come forward. This gentleman is the appellant and owner of the property located at 414 East Trinity Lane. He is requesting variance in the paving provisions, the driveway width, and perimeter side landscaping along that driveway in RM15A to renovate the existing residence and convert to a triplex or a three-family dwelling, referred to the board under Section 1720-060. G and A and 1724-150. The long and short of this case, let me give you our part of it. This entire strip of Trinity Lane in this block face was rezoned recently to multifamily. The gentleman before you recently purchased a property, and I'll let him discuss when his time comes up about when he purchased it. But he came to see us about obtaining a permit for rehab on this structure. Our Property Standards Division has been on the gentleman on trying to repair this property. His assertion to us is that this is a legal triplex. Our records, I can't find a single record indicating beyond two-family dwelling. But there are 3 electric meters on this property. There are 3 distinct A, B, and C mailboxes, and they have been for some time. There are 3 separate entrances separate from each other into the structure, but we just have no records to indicate a legal 3-family dwelling. So we told him, said, sir, before we can issue any permits to rehab, you're going to have to appeal. You're going to have to comply with what we would make 3 families do. Because for us, it's a change of use from duplex to triplex, because we have no permits showing that this use was ever changed.
But the triplex is legally conforming.
I don't know, sir. In our opinion, it is not, because I have no records to indicate such. But
But we're not going to discuss that part.
We're not
today.
discussing.
No, I'm saying if it were a triplex.
If it were legally conforming, he would not be here.
Okay, all right.
If I had records indicating a true legal triplex, he would be grandfathered from these provisions. So in trying to get him corrected, he now has to comply with the paving requirements and the driveway width for multifamily developments, as any other would. And multifamily, when I say that, that's for unit 3 or more units. Not single family, not 2-family, but 3-family has to do different things than 1 and 2-family. So, of course, this appeal's been initiated because the gentleman honestly would like to continue to use it as it's laid out today. This is the subject property on the aerial photographs. Hey, Linda, can you get them stepped just outside? They are not... the property maps are accurate and the aerials are accurate, but not with each other. So always be careful of that. So the subject property here, let me show you. This is the site plan provided by the gentleman. He actually has I do have a grandfathered mobile home on the adjoining lot. It's, according to the survey, is sitting 6 feet onto his property. And you'll see that here in the photographs. But this is the structure in question. This entrance is off facing Trinity Lane. This is unit B, I believe, is the unit. These are the homes to either side. And then this is the back of the structure. There's an entrance here, and there's a separate entrance on the side of the home. If you can see it right here, these steps leading up into it. So 3 separate distinct entrances, but again, I didn't have a record. But for 3-family dwellings, the driveway width to serve the parking area at the back has to be 24 feet in width. And he's only approximately 14 feet in width there. That's this driveway width here. And then this area back here is gravel. We require pavement for multifamily. But just on the side of the home, and I don't have a photograph, just here is a meter base. We talked about 2 families and meters. There are actually 3 meters on this property. I cannot find a record on how the 3rd meter got there. I have plenty of evidence for 2 meters and a duplex and all that, but I can't find how, but it's clearly there, and it's in operation, and it has been doing so for some time. So really the request before you is not, is it a triplex or not? He's trying to obtain a permit to make it a legal triplex based on the record, but does he have to conform with these provisions of driveway width and paving and such? Here at the back, he's 15 feet on his driveway instead of 24.
And this landscape buffer.
And the landscape buffer, and that buffer is just along the driveway. It's a 5-foot perimeter landscape strip along that driveway there. So that's what we have. I understand that how this came to us, and you guys sometimes are wondering, this was a complaint process that drove us to go out and look at it and say, hey, you have to fix it. And he comes in to get a permit and say, hey, you're not, so it kind of led to this appeal. So with that, I'll turn it over to you, sir. If you would, please identify yourself and make your presentation to the board.
You can proceed.
Yes, and because the driveway is built 1938, just 10 foot wide, and 1 to 2 feet perimeter wide landscaping. I cannot. It is impossible for me to comply with the zoning code. Require 24 feet.
You're saying that the lot is too narrow for two?
Yes, sir. It's narrow, just 10 feet. So zoning code require 24 feet. I cannot say.
There's nowhere to put 24 feet of driveway.
Yeah, okay. Yes. Because existing the building and the neighbor border, we cannot make bigger, so it is impossible for me.
Can I ask a question from the codes department's standpoint? You're not proposing any additions to the building? You're not going to make it larger?
Cannot make it.
You're just renovating the inside?
Yes,
okay.
Sir.
That's what I needed to.
Impossible to make bigger.
Do we have any other questions? Okay. Would you have anything else you'd like to say?
These all.
Okay. Then I'm going to move to close the public hearing. Discussion?
Yeah, I don't think it's physically possible to. And I'll let someone else figure out if it's really a triplex or not later, but obviously there's only 15 feet there, so I don't, there's not even room to get a normal drive and a landscape buffer, so I would be okay with allowing the variance for both of those.
And what about the paving?
Oh, right.
The paving, there was a concern about health in his written proposal, which is part of the record that his tenants.
But I don't know that we can use, I personally am okay with gravel. I think as far as runoff and everything, the gravel's okay, but I don't know. I don't know what hardship we can show for that. Unless the paver can't get back there.
Or it's very close to the property line. Not that that's in the code, but I wouldn't want, if I'm the neighboring property, to have basically pavement right up against the property line.
What is the other thing we can use in hardship? Something about unique conditions or. We've used it before, and I can't remember what we call it.
Well,
John Michael, the catch-all category.
Well, but also, how about this? We're we're supposed to determine whether there's harm to the public welfare, and literally his complaint is that years ago I did have a plan to have parking lot at this triplex, but some tenants did not wish to have it, caused their poor health problems. Some said they were sensitive to the asphalts, which made them sick, especially in summertime. So we could say it was actually a positive influence on the public welfare.
I think that's good.
Okay, with y'all's permission, I'm going to move that the board approve the variances requested because all of the requirements of MCL 17.40.370 have been met, and the board finds that the unique characteristics of the property are the narrowness of the lot and the appeal to preserve public welfare by not paving the lot. That's a motion. Is there a second?
Second.
Got a motion, got a second. All in favor? Aye. Any opposed? Passes.
Okay, your case is approved on the vote of five.
Thank you, sir. Thank you.
With that, the Board of Zoning Appeals is adjourned. Thank you.